ownership. Okay, it depends who is keeping or harboring the animal. This is called in the law. So if you're boarding a horse, you might be liable. And the owner might be liable. You got to keep that in mind. It's harboring. It's not just ownership. Okay, loose and wandering. Negligence, the court says here, can be made and maintained against an owner of a horse or cow which is unsupervised and uncontrolled on a public road, where the animal causes damage or collides with a person or vehicle. Okay. That's a quote from the court. The court didn't really mean negligence when they said that. It meant strict liability. This is changing a little bit in New York, though. But the theory is generally that horses don't go out on the road unless somebody was negligent. Somebody left the gate open. Somebody didn't put the chain around it. If you can show that the owner wasn't negligent, this is the first time the horse got out, maybe a tree fell on the fence and let the horse get out, you've got a good defense to it. I said it's changing. In April, and this is discussed in the article that's in your packet, the 3rd Department issued an interesting case. It was with a cow. This was April of this year. The plaintiff was injured. Her vehicle collided with a cow which was wandering on the local road out in Franklin County. It was late at night. You had a pretty horrible injury when the cow went through the windshield. The cow was owned by a co-defendant of the primary defendant who owned the farm. The cow was being corralled at that farmer's feedlot prior to being shipped out for slaughter when somehow it escaped. The court doesn't tell us why or how it escaped. Somehow it got out. Now, the plaintiff didn't have a very good lawyer and sued the defendants and only pled negligence, never pled strict liability, never said you're strictly liable for that. Usually in that case, since you can't have recovery for negligence, the court tosses the case out. Fine and dandy. That's what the court did down below. When it went up on appeal, instead of just rubber stamping it, the court goes through the whole discussion, rubber stamps it, and then says something that's kind of disturbing for horse owners. He said, we believe in the limited circumstance the traditional rules of negligence should apply to determine the legal responsibility of the owner for the damages it might have caused. However, we're not going to change the rule today and do away with strict liability. The theory was here, you've got a cow that weighs 1,500 pounds. It's out, it hits a car, it has the potential to do horrible damage. Whereas you have a dog that goes out and gets hit by a car, only the dog's going to be damaged, there's minor damage to the property. The court came very, very close, I think, to overturning strict liability. That's bad for you that owns the cow or the horse, because now you can just be hit on negligence, if that happens. The courts in the 1st and 2nd Department have already partially overturned strict liability. So I think in the next 5 years, strict liability is going to be gone, and it's just going to have a negligence standard, which is really going to open the door for animal-related litigation, for bites, kicks, auto collisions, and things like that. So it's really, it's kind of in limbo right now. It's legally interesting to me, but it certainly has huge impacts coming down the road.
Jonathan?
Yeah.
So if you're a horse or farm owner and you have a sign on your horse's stall, for example, it says this horse bites, and somebody puts their hand in there anyway, are you protecting yourself at all?
It depends. Do you have knowledge that the horse bites or not? You just put up the sign.
Yes,
Okay.
you have knowledge.
If you have knowledge, you're on the hook, and that sign can probably be used against you. If you don't have knowledge, I was going to cover this in an hour, but I'll do it now. We were all taught in law school that when you put the sign up on the house that says beware of dog, don't do that, because then you're saying that you have knowledge that your dog is vicious. That's not so in New York. If I just have a beware of dog sign and there's no reason that I know that my dog is vicious, it's never attacked anybody, never barked at anybody, never bit anybody, I can have the sign that can't be used against me in court. Same thing for a horse. But if you have that knowledge and you put that sign up, that's additional evidence that you knew. You're going to be sitting in your deposition, and the plaintiff's attorney is going to ask you, well, has your horse ever bitten anybody before? Oh, yeah, 3 times. Oh, well, is that why you put the sign there? Why, yes.
So the things that people think they're doing to protect themselves are actually going to go against them?
It may. it may. Also, I'll give you a real life example. We litigated a case for a local university that hired an electrical contractor to come in to fix a power outage. This was in a main, one of the huge buildings on campus. It was a lot of electricity to power that building, about 4,000 volts coming through an electrical box down below. They hired out a contractor to come in because they didn't know what to do. There were 2 doors to get to that box. There was the first door that only the employees of the college had keys to. They opened that door for the contractor to come in to get to the electrical box and to fix the problem. The contractor comes in, goes through the open door, our employees back away and leave. He takes out the 6 1-inch bolts on the front of that panel that has the huge sign, danger, 4,000 volts, make sure the electricity is isolated. Takes them off, pulls it out, never uses his electrical tester that's strapped to his leg. Meanwhile, the lights are on. Okay, lights are on and they're on. Sticks his hand in that box and yanks on the cable. $4.5 million later, our client was held liable. Why? We opened the first door. The warning sign didn't matter. Now, fortunately, we had great contracts in place. We had great insurance. They had, not to pat myself on the back, but the other 3 or 4 lawyers that worked on the case, we had a great legal team. We were able to recover all of that money back for the client through insurance and other litigation, and ultimately only cost them $500,000 out of pocket. But that's just an example of how a warning sign is absolutely meaningless when it goes to the courts. The guy wasn't killed. If he would have been killed, it would probably have been a lot less of a verdict. But he is, of course, horribly maimed for the rest of his life, and the court is not going to want to take away that money from that plaintiff. We appealed it all the way up to.
Is that a jury court or just a?
Yep, it was a jury verdict for the 4.5. Then we appealed on the warning sign issue. The appellate court disagreed with us, and the Court of Appeals refused to hear the case. He got his money. But we had insurance.
At the very beginning of this presentation, one of the things I thought I saw up there was that you said we should have signs up on our property to protect ourselves.
You should.
Now you're telling us that we shouldn't have signs up because it's going to just pin us to the wall.
That's why you should talk about it with your lawyer. Also, at the beginning, I said that every circumstance is different. Again, if you have a sign, really isn't going to hurt you, unless it's in the case that she pointed out that you know that there's something wrong. If you're doing construction and you've got a giant hole in the ground, don't just put up a sign, caution, big hole. Put some fence up and put a sign up. Make it a little harder for people to fall into it. There's a couple different steps that you could take other than just that sign. Ultimately, at the end of the day, it's probably going to be a small issue when it comes down to it.
I'm sorry to open up the question, maybe we're interrupting your
Go ahead.
presentation. Before you mention the fact that horse throws a rider, is there a distinguishing difference between a horse throwing a rider and a rider falling off the horse?
It's a good defense. I don't know what circumstance.
I mean, I could have a beginner rider doing a walk and he slides off the saddle, or I could have a bronking horse and throw somebody off. There has to be some distinguishing factors and characteristics to make that.
Well, that would come under the propensity for the horse to be dangerous to start with if you knew it bucked.
Right.
So that would make it a different case.
Well, maybe buck was the wrong word. Let's say a horse spooks, a bee stings, and a fly lands on him. I mean, does that make the horse dangerous?
In that case, I would say no. I mean, in that circumstance, if nothing has happened with the horse before and a bee stings and it jumps up and throws the person, I don't think they're going to be able to prove the propensity.
My original question was, is there a difference between falling off and being
it's gonna be a defense to it. It's not gonna prevent someone from suing you. You know, we all know you can be sued for anything, hot coffee, whatever. Watch yourselves tonight, there's not lids on anything. But, you know, at the end of the day, it might save the day. You know, I don't know, that's interesting.
You know, a good rider will always say, the horse threw me.
Right.
You know, bad rider will say, I fell off.
Well, hopefully they say that, or we can get it right. You know, in that case too, if someone just slides off, you're probably gonna have much less of an injury than if someone is thrown. Which is gonna make a big difference too. Make sure they're all wearing helmets.
Yes.
You should have in your waiver too that if they refuse to wear a helmet, if you don't absolutely require it, which I would recommend, if they refuse to wear it, you should have them check an additional portion that says they've been offered it and refused it. Make sure anybody under 21 is wearing a helmet. Any other questions or anything? Feel free to interrupt me. Perfectly fine. As I said, the first and second departments follow something a little bit of a different theory. They hold that there's an enhanced duty in special circumstances. Nobody knows what that means, but I've got some examples. What we do know is that this enhanced duty is a distinct act that the defendant should have done or should not have done, or is a situation which gives them a special duty of care. It'd be similar to a nurse that's witness to an accident scene that has the ability to help someone but doesn't. And this is what's discussed in my article that's in there. We got two cases that are going to give two competing views on this. We have one from the third department, which is the Bard case, cited all the time in litigation, and the Germain case from the second department. Okay, Bard involves a bull. The bull was loose in the barn. A carpenter was hired by the farmer to come in and do some repairs to the barn. The bull pins him up against the wall and ruffles him up with the horns a little bit. The bull had never gotten out before, never injured anybody before. The plaintiff came up with a pretty clever idea. He said, we're going to get a scientific expert that's going to come in, do a DNA test or do some testing to the bull, and testify that that breed of bull is generally dangerous genetically.